Let me begin with a story you won't forget. In 2017, a Pensacola widow sued a pharmaceutical giant over her husband's wrongful death. Her lawyers in state court had damning evidence and a sympathetic judge. They had a winning hand. But they made one fatal mistake. The corporate defendant filed a notice of removal, moving the case from state to federal court, a move that is often more favorable to corporate defendants. The notice triggered a hidden 30-day clock for the widow's lawyers to challenge the removal and send the case back to state court. They missed the deadline by 1 day. The case was now permanently stuck in federal court, where a different, stricter set of rules applied. The defense filed a motion to dismiss on a technicality that would have been easily fixed in state court. The federal judge agreed, case dismissed. That widow never got her day in court, not because her case was weak, but because her lawyers didn't master the rules. This is civil procedure in Florida. It's not just paperwork, it's the invisible battlefield where cases are won or lost before a single witness takes the stand. I'm going to show you how these rules work in practice, from the moment a client walks into your office to the final appeal. The first gate, jurisdiction and venue. Before you can fight, you must be in the right court. This is jurisdiction, the court's very power to hear a case. Imagine a Tampa fisherman buys a defective life vest from an online retailer based in Oregon. The vest fails, and he wants to sue in Tampa. Can he? The answer lies in Florida's long-arm statute, Florida Statute 48.193, and a constitutional test of minimum contacts. It's not enough that the company's website is accessible in Florida. The courts require substantial and not isolated activity. So if our fisherman bought the only vest that company ever sold to a Floridian, probably no jurisdiction. But if discovery reveals they've sold 10,000 vests here through targeted ads, that's purposeful availment. That's a different story. Getting this wrong means your case is dismissed before it starts. You also have to be in the right level of court, subject matter jurisdiction. In Florida, cases under $50,000 belong in county court. Cases over that belong in circuit court. File in the wrong one, and your case can be dismissed, potentially after the statute of limitations has expired. Finally, venue, Chapter 47, dictates the correct county for the lawsuit, usually where the defendant lives or where the incident occurred. Choosing the wrong venue can lead to costly battles over motions to transfer. The opening salvo, pleadings. Once you're in the right court, you must state your case in the complaint. Florida Rule 1.110 requires fact pleading, not vague accusations. You must plead ultimate facts. I once saw a $15 million medical malpractice claim dismissed because the lawyer wrote, "Defendant was negligent." That's a legal conclusion. The judge allowed them to amend, and they changed it to, "Defendant's employee, Nurse Jane Doe, failed to sterilize the surgical instruments according to AMA guidelines, which directly caused plaintiff's infection." One is a conclusion that gets your case thrown out. The other is a set of ultimate facts that lets your case survive. The difference is everything. The defendant's response, the answer, is just as critical. This is their one and only chance to raise affirmative defenses, for example, statute of limitations, comparative negligence. If a defense lawyer forgets to plead a key affirmative defense, it is waived forever, potentially costing their client the entire case. The search, service of process. A perfect complaint is worthless until it's properly delivered to the defendant. This is service of process, Chapter 48. While you can use the sheriff's office, a pro tip is to always hire a private process server for corporate defendants. Why? Because under Rule 1.070E, when a process server serves a company's registered agent, it creates a powerful, almost irrefutable presumption of valid service. I watched a developer dodge a multi-million-dollar lawsuit for years by claiming he was never properly served. The case finally moved forward when a new lawyer hired a process server who simply served the developer's mother, his official registered agent, at her home. The developer's years-long charade ended in an instant. The battlefield, discovery. Discovery is where the war is truly won. It's where you demand documents, answers, and testimony. The scope is broad, anything reasonably calculated to lead to the discovery of admissible evidence. Most lawyers use interrogatories, written questions poorly. Asterisk. Bad question. Do you have any documents about the accident? This invites a no. Asterisk. Good question. Produce all maintenance logs, incident reports, and employee disciplinary records for the 24 hours preceding plaintiff's fall at your Orlando location on June 15, 2023. This gets you the smoking gun. Depositions where you question witnesses under oath are even more critical. I once deposed a corporate vice president in a product liability case. I asked him if his company had ever received safety complaints about their product before my client was injured. He looked me in the eye and said, "Absolutely not. It was a lie." Because I had won a motion to compel their internal records, I had his own email in my briefcase. I placed it in front of him. It was from 2 years prior, addressed to the CEO, and it said, "We've had 12 slip and fall incidents this quarter. We need to address this liability." The blood drained from his face. His lawyer put his head in his hands. The case settled for a life-changing sum the next day. That only happens when you use the rules of discovery to pry the truth loose. The tipping point, motions practice. The motion for summary judgment, MSJ, is a weapon that can end a case without a trial. Under Florida's Rule 1.510, which recently adopted the more effective federal standard, you can win if you show there's no genuine dispute as to any material fact. I once won a case before discovery even started because the plaintiff in his deposition couldn't identify a single witness who saw the alleged event. We filed for summary judgment. The judge agreed they had no evidence and ended the case, saving our client a fortune. But beware, to win or oppose an MSJ, you can't just rely on pleadings. You must file actual evidence, affidavits, deposition excerpts, documents. Miss that requirement and your motion is dead on arrival. The endgame, trial and appeals. If you get to trial, procedure becomes performance art. Every objection matters for the appeal. I once lost a $2 million verdict because an exhibit's Bates stamp number was off by a single digit from our official list. The judge, a stickler for the rules, excluded our best piece of evidence, the defendant's admission of liability. This leads to the brutal truth of appeals. Most are lost before they're filed because the trial lawyer failed to preserve the record. The appellate court can only review what's in the trial transcript. If an opponent says something improper and you just yell "objection" without stating the legal grounds, "objection hearsay," you have waived the issue. It's as if it never happened. A multi-million-dollar error can be caused by the omission of a single word. Conclusion, the soul of the rules. Let me leave you with this. In 2019, the Florida Supreme Court amended Rule 1.010 to emphasize that our rules exist to secure the just, speedy, and inexpensive determination of every action. Notice the word order. Just comes first. That is your guiding principle. Every motion you file, every objection you make, every pleading you draft, ask yourself, does this serve justice? If the answer is yes, the procedure will follow. Your homework is to read Rules 1.100 through 1.200. Study them, because next week, we'll workshop a complaint that survived a motion to dismiss against one of Florida's most powerful firms. Until then, remember, in this courtroom, procedure isn't just the rules of the game, it is the game.